Good morning, everyone, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 a.m. to provide landowners valuable information you need regarding the natural gas development here in Pennsylvania. And if you are looking for landowner information, this is the show for you. And of course, at the Clark Law Firm, my focus is on landowner and only landowner representation. And I have and continue to represent my clients and Pennsylvania landowners for such items as gas lease negotiations, of course, the royalty challenges involving deductions, and are companies appropriately taking deductions, or are they excessively taking deductions, or are they taking deductions when the contract actually precludes them to take these deductions for items like gathering and transportation. We'll touch a little bit on that today. That won't be the focus of today's show. We also represent, I do, for pipeline right-of-way agreements. I'm getting to the point, I think, where I can at least say this, that I've represented clients in close to, maybe more, maybe a little less, but close to 50 separate companies, pipeline companies, in negotiation for pipeline right-of-way agreements. So, again, I say this, the point is, we do this show, we want you to get information, and we have a wide base of information to draw from in negotiations with well over 40 companies and probably close here now to 50 companies across Pennsylvania. So looking at what can we do, what can we improve, what can we get better, what can we learn from, and not just northeastern part of Pennsylvania, but all across the state of Pennsylvania as well. Another thing I talked a lot about in the last couple of weeks, been doing more and more and have been doing for some time, a lot of agreements relating to amendments and modifications of existing oil and gas leases. What that means is if you have an oil and gas lease, something that is very common and more common in recent times than it has been in some others, and these tend to come in waves. But recently what we see is we see that companies are coming to landowners and they're saying, hey, you have an oil and gas lease. Maybe it was done in a group is something that we typically see and something I'm seeing a lot right now. And the company's coming back and said, we'd like to change some of these terms in your oil and gas lease. So we're not going to just drop your lease and offer you a new one. What we want to do is issue you or offer you an amendment or modification of your existing gas lease. And these documents, sometimes they're not terribly complicated. Sometimes they only involve increasing, or the company asking, hey, instead of having a maximum of 640-acre units under your gas lease, would you agree to an amendment or a modification to change your gas lease to allow us to create a larger unit? Sometimes we see those units go as high as unlimited. Other times we see like 1,280, and usually we don't see units that large, but this is a very common occurrence of what a landowner may receive as an amendment and modification. That's the simplest form. What we see is another form, or many other forms, and they're much, much more complicated. And I think I talked before about the Friendsville lease, and it doesn't just have to be the Friendsville. There's many others that have a lot more detail than maybe the standard typical company form lease that many people entered into many years ago. So what happens is landman comes out, company representative comes out and says, hey, we'd like to amend and modify your lease. And they give you this document, maybe it's 2, 3, 4, 5 pages long, and it can be very, very tricky because sometimes it'll say the third sentence in paragraph 5A is deleted and added in this sentence. Or maybe it may say the words and the are deleted in paragraph 24, subsection I, paragraph or sentence number 2. And instead, we're going to add these words. So it can be very, very tricky, and sometimes there are pages of these. So it's really important, number one, you understand what's being asked, and then also you understand what impact this is going to have on you. And the most important thing in this process is to understand, I guess it's not the most, all of it's important, but you need to understand what you're being asked to do. But what's also terribly important is to understand what your leverage is to either say, no, I don't want to do this, I'm going to stay with the lease I have, to try to maybe to negotiate. Maybe you can do a little better. Maybe you can change some of these terms. And I stress maybe, because every individual circumstance is different. So you look at that and you say, okay, what are they asking to change and what can I do about it? And in many cases, unfortunately, there's little to nothing you can do, but in some cases there are things that you can do. But even if you can't do anything, you need to understand what I'm being asked to do. Why can't I do anything? Because sometimes you can do things. So it's very, very important. So I've been doing a lot of lease and modification reviews. And to add to the difficulties facing the landowners, sometimes too, in these amendments and modifications to the original oil and gas lease, the landowner is also asked to consent or give approval to assignment of their lease to a second company. So the company that's coming to you with this amendment and modification, they're also asking you, hey, will you agree or allow us to change your lease and then assign it or transfer it to another company? So you got to watch out for that. And I did a couple segments of a show a few weeks back talking about, one of the concerns that you need to have. I do a lot of this talking, and I'm going to talk some today, but it's not going to be a focus on this market enhancement clause and deductions. And so think about this. I did a whole show, so you can go back. And a reminder, you're listening to All Things Marcellus with me, Attorney Doug Clark. We're here every Sunday from 8 to 9 a.m. But if you miss any of today's show, or you're hearing for the first time, or one of the first times, you say, hey, boy, this is the first time I ever heard this. I wonder if there's anything else out there. Well, we've been doing this show since August of 2010. So August of 2010, we're going to be closing in here on our 4th year of doing the show. What we do is on the websites at pagasleaseattorney.com and pipelineattorney.com, we post the shows. And what we're doing now is we're posting them up the following day. Now, you may say, you told me that last week, and I went on the website at pagasleaseattorney.com, and I didn't find a show. Well, I apologize. We were having some classic technical difficulties, but we're getting up to speed because we just started doing this, posting it each week. Also, there was apparently, too, just a quick little side point, I guess these wildfires in California actually impacted our websites. As far as there was a fiber optic cable that apparently burned or melted, and again, please don't hold me to this. This is at least what my guy tells me. And we lost access to the website for a little while this week. So we're back up and at 'em. We're going to be doing a better job. We're ironing out these bugs. But if you want to check out the show, pagasleaseattorney.com. First off, there's 140 plus hours of radio shows available. Just go to the websites, check them out. Been doing the show since August 2014. Also, we're going to be posting. So if you can't tune in every Sunday from 8 to 9 a.m., check it out all during the week. We're going to post up this week's show so it's available as well. We want to make sure everyone's getting current, fresh information because, believe me, everything we're talking about is evolving over time. Every single thing. Gas leases, pipeline agreements, royalty issues, estate planning issues. Everything is evolving over time. So check out pagasleaseattorney.com. Check out some of the old shows. Get some information there. Okay. Turning back here, I want to get back to these amendments and modifications. Again, what we're seeing is people are being approached, and I'm bringing it up again because I'm dealing with this a lot recently. People are being approached and saying, hey, will you amend or modify your oil and gas lease? I have to say the most important, I kind of bounced around, but the most important thing first is understand what your lease says and what they're asking to do. Then understand, which is equally important. That's how important both things are. You must understand what you're being asked to do, but then you must understand whether you have any leverage to either negotiate this to try to maybe lessen the impact of what's being asked, or you have the ability to say no, and a company is forced to operate under your lease for practical purposes. And when I say that is that, the company could always, in most cases, the company could always surrender or just give up your lease if you refuse to comply. But in practice, that's not going to be always what you'd see. For example, if the company approaches you and they want to modify or amend your lease, and you're sitting there with a well site on your property, and whether you have one well or 4 wells, it's very unlikely that the company is going to surrender or give up your lease if you refuse to sign. One possibility that we see, say you're a person in that circumstance where you have a lease out there and the company wants to amend and modify it, and you may have a well bore underneath your property, which gives you leverage. You may actually have it, make a simple case, the actual wells drilled from your property. Well, you might be in a situation there where you may be able to negotiate some sort of compensation if you want to do that. So you have to understand these circumstances. Then you want to talk about, I want to touch on before the end of this segment here, you may be asked to consent to assign to another company. It is very important that you understand what is your lease, what is in your lease, and what your company, what their interpretation is of your lease. So what I mean by that is this. Say you're a person who has the market enhancement clause in your lease, and say you are leased to Cabot Oil and Gas. Cabot Oil and Gas is not taking deductions for items such as gathering, transportation, and compression from the wellhead to the interstate pipeline, like the Tennessee pipeline. They're not taking these post-production costs. They're not deducting them from the landowner's royalty checks if you have the market enhancement clause or a similar language or a similar clause. That's very good for the landowners. That's what our position is. If you have the market enhancement clause, you're not authorized to take these deductions from the wellhead to the interstate pipeline. Cabot doesn't do it. Many other companies don't do it as well. But we know, if you listen to the show, Chesapeake does do it, and that's the basis of what our lawsuit, our arbitration against Chesapeake is, and our motion and intervention action, our motion to intervene in the federal case of Demchak versus Chesapeake. So we'll touch on that some more later. But what we're looking at here then is this. If you're leased to Cabot, and Cabot approaches you and they say, hey, we want to have you consent to assign your lease to a third company. And this third company happens to be Chesapeake. Now, I use the example of Cabot. You could be leased to Southwestern, doesn't take deductions. Talisman doesn't take deductions under the market enhancement clause. So if these companies come to you and say, hey, we'd like to get your permission because your lease says that if we want to assign your lease to another company, we have to get your consent. However, your consent cannot be unreasonably withheld. So we have to ask you, but you can't be unreasonable. Well, it's hard in a lot of cases to come up with what's a reasonable objection for you as a landowner? What's a reason? They just want to assign it. What's your reason? Why are you going to say no? Well, this is to make you think here. Here's a potential reason that you may have, which would be potentially, in my opinion, very reasonable. If you have the market enhancement clause or ready for seller use clause, and the company that you're leased to does not take deductions, it's very important that you understand that because you may not even be getting royalties yet. So you have to understand first, how does my company that I'm leased to today treat this provision? So let's say they don't take deductions and they want to transfer or assign your lease to Chesapeake, who we know does take deductions. What do? You have the right to say, you know what? I don't want to consent to assign my lease to Chesapeake because I know that they're going to start taking deductions, which can be thousands, tens of thousands, and hundreds of thousands of dollars over time, depending upon your acreage and many, many other variables. So it can be a reasonable position to say, you know what, I'm not going to consent to this because it's going to cost me a lot of money. And again, if you have 1 acre, it's not going to cost as much. If you have 10 and more, and we can do that out, 100, 500, whatever numbers we want to use, 50, 25, that can be a substantial amount of money. And I would submit that clearly that's a reasonable basis to say, you know what, I don't want to consent to this. However, that's not, stress, it's not specific advice for everybody. And it's not the end of this evaluation. I'm up against the break. We'll be right back. I'm going to talk a little bit about this some more. I am Attorney Doug Clark. You're listening to All Things Marcellus. We'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And a reminder, we are here every Sunday. I am here every Sunday from 8 to 9 a.m. But if you miss any of today's show, you can go back to pagasleaseattorney.com, pipelineattorney.com. Great websites. Well, little me saying that, I guess, but we get a lot of compliments, a lot of great landowner information. So if you're not looking for representation, you're looking to learn some more, go check out pagasleaseattorney.com, pipelineattorney.com. It's a rainy day, you want something to do in the background. 140, I think we're at 145 hours or more of radio shows. So we touch on, I've talked about everything. We have industry guests. We're going to have some more industry guests on in the future. I talk about gas leasing, pipelines. We're going to talk about some pipelines today. Talking about amendments and modification. I want to get back to that, but I want to explain, briefly. This will be our quick little, hopefully quick, section, or relatively quick section on the royalty issue. So, okay, I talked about these post-production costs. Just want to remind everybody, first off, number one, I do free, confidential, no obligation whatsoever evaluations of any Pennsylvania landowner or royalty owner's gas lease that I'm looking for the issue of, do I believe that you're having deductions taken from your royalty checks that are not authorized under the terms of your oil and gas lease? So what we're looking for primarily, we're looking at, do you have what's called a market enhancement clause or similar language? And I've seen leases dating back to 2006 that have this language. So my position is that if you have this language, that deductions for items such as gathering, transportation, compression should not be taken from your royalty or the gross royalty. You should be getting paid royalties based upon the sale price at the gas at the interstate pipeline. For example, the Tennessee pipeline, the Transco pipeline, perhaps the Millennium pipeline. That's where your royalties should be calculated at if you have that language, in my opinion. So we have our arbitration case. I represent now, I think we're at 160 individual clients, well over 5,000 acres that we represent in our case against Chesapeake, asserting, hey, you're not paying royalties properly. And we can quickly point to Cabot, using this example, the first segment, Southwestern, Talisman. We can point to Statoil, Mitsui, WPX, and others who, if you have this language, are not taking any deductions for post-production costs such as gathering, transportation, compression from the time that the gas leaves the ground at the wellhead to the point of that interstate pipeline, sometimes called the connection line. So what I'll do is if you send me your lease, and what's really important about this too, you don't even need to be getting royalties yet, because there's the proposed class action settlement, which is pending, which we've challenged, and it's pending in federal court. And it says that whether you're receiving royalties or not, if you are leased in whole or in part to Chesapeake, in whole or in part, that this settlement would apply to you. So you may be sitting out there, well, I'm not getting royalty checks, this has nothing to do with me. Well, if you're leased in whole or in part to Chesapeake, and you have the relevant language, you have the language in there, this settlement would apply to you. So you need to know. And, you need to know whatever you decide, but you need to know, am I part of this? Does this language apply to me? And that's why I say I do these evaluations. I do a lot on the weekends. I do them in the evenings. I come in early. I want people to know. And I stress that because I don't follow up and say, hey, you need us to represent you. We need to attack this. We need to do something about this. Sign up with us. That's not what we do. What I want to make sure is that you get the information. You know where you fall in. Does this apply to you? And whatever you want to do after that, that's your decision. But you need to know. People need to know. And then make the decision for yourself. I'm getting fired up. I say this all the time. Education is the key. Knowledge is the key. Get your education, get your knowledge, and make the right decision for you. Make your own decision, but you have to be informed to make the right decision. There is a lot of money at stake here. There's a lot involved. And this proposed settlement would apply for the lifetime of the lease. And just quickly, The outline of the terms of this proposed settlement as far as the financial aspect is that instead of Chesapeake taking 100% of these deductions, which many companies take no deductions whatsoever, they're going to deduct 77.5% of these costs. 77.5% Chesapeake is going to keep for the lifetime of the lease of these post-production costs, and that's from September 1st, 2013 moving forward. So I talked to a lot of people that just don't understand that this may apply to them, and I do these reviews and we inform people. If you say, hey, you know what, I like this, I support this, I think this is a good idea, that's great, that's your opinion, you're informed. Be informed, make those decisions. I am Attorney Doug Clark. You're listening to All Things Marcellus, and just a reminder, we're here every Sunday from 8 to 9, and to finish this, you can send me, just contact the office, 570-307-0702. Again, that's 570-307-0702. Make arrangements. You can send me the lease. Send me your royalty checks from all the companies. One check is all I need to do is to see, and I'll get back to you in writing and let you know what my opinion is, whether this applies to you. You should definitely take advantage of this opportunity. Learn, become informed. You can also go to the website at pagasleaseattorney.com. We have a whole section dedicated to this issue. We have actual court filings in PDF format that you can go check out. And you can go, the Demchak versus Chesapeake case is filed in the Middle District of Pennsylvania, and that's the case where we filed our motion to intervene. And all of those documents are available at public record. Become informed. Now, there's thousands of pages out there, but become informed and understand. This is the biggest issue facing Pennsylvania landowners. The biggest issue. So, want to step back again. Remember now, I was talking before about many landowners are getting these requests to amend or modify, which means change the terms of their original oil and gas lease. That alone, you need to understand. You need to understand what's being asked, and you need to understand, do you have the ability to say no? Well, yeah, you do, but if you do, what's going to be the impact? And so you got to be very, very careful. In my opinion, you'll hear me say this often, whether it's me or somebody else, if you're faced with an amendment and modification, you should at least sit down. Take the hour to 2 hours, whatever it is, sit down with an attorney that understands what this is about, that can guide you and instruct you and explain to you what your options are and what this means. You must understand this. If you simply reject this offer, it could have significant negative ramifications for you. It may have positive ramifications, but you have to know. Also, you may have an opportunity to improve your prior position if you understand what your leverage is. Now, you may be in a position where, you know what, you really have no leverage. The market today is not what it used to be in this area, and if you don't extend it and it expires, your lease expires, you may be in a far worse position than if you did agree to this amendment, modification, or possibly extension. So you have to understand this. And again, if you call me, call somebody else, but you have to understand. And as I say all the time too, this show is about getting information out there, and there's commercial aspects to it, and obviously I run commercials in between, and talking about doing the free evaluation, confidential. We want people to be informed, but information, that's the basis of this show. That's what I try to do each and every week, is get news, get things that are coming up, and get that information out to you, the landowner, making sure that you're understanding with the legal aspects of what I am seeing, the issues that I'm seeing landowners deal with. And one of the issues that I'm seeing a lot recently are these amendments and modifications. So we need to make sure that you're thinking about these issues, that you're understanding that there's more to this thing than just go ahead and run and sign it. You need to understand what it is. And ultimately, the advice may be, hey, look, I strongly recommend or advise that you go ahead and sign this, and I don't think you can change the terms, and let's go ahead and get this done. You need to understand, is that your circumstance? It's very, very important. All of these documents are important, and you need to make sure that you're doing the right thing for you and your circumstance. Very important. So again, if you need any assistance, you can always contact me. I don't want to make this a big commercial. I want you to understand that everybody should be getting some assistance with this because these can be very, very tricky. And my show here, what I'm talking about, is not specific advice for any single person. There are times where, rarely, but times where we've been able to parlay this amendment and modification into either compensation, sometimes a royalty rate increase, but that's rare. So you can't sit there and say, well, you should negotiate for a higher royalty, because that's really, really rare. The idea is you need to be able to identify, do you have that ability? And if you don't have the ability, then there's still things you need to identify. Do you have any ability to change some of the terms? Have I seen the company be flexible with some of the terms that we can maximize? We don't want to be in a situation where you go to your attorney and they're giving you all this crazy advice that you can make all these changes, and they've never seen this before and they've never went through this process, and all of a sudden you end up with a big, long, large legal bill and nothing changed. Or you get bad advice and you don't sign, and next thing you know, you're out of a unit. You got to make sure that you're getting assistance and getting good, credible, knowledgeable help from whomever it is that's assisting you. I am Attorney Doug Clark. You're listening to All Things Marcellus. A reminder, we're here every Sunday from 8 to 9 a.m. But also, go to the website. We post up the shows. You can go check them out there. PAGasleaseattorney.com. pipelineattorney.com as well. I do tons of pipeline work and want to make sure that you go there. We got like frequently asked questions. We got like 10 things to think about, those type of things. Go check that out. Get a basic understanding. When somebody comes to your door from a gas industry representative, when they come to your door, landman comes to the door, I'm going to start saying this every single week. Remember, look at their business card. They don't work for you. So first thing you want to do is you want to listen, get information, never agree to anything, never agree to compensation. Listen to what they have to say, and then get some assistance. Because I do these pipeline agreements, and there's so many different types of agreements. Sometimes we have this incredible amount of leverage. Sometimes we have hardly any leverage. So we want to get in and get out with the best possible agreement we can. But you as a landowner need to understand your position. I have seen pipeline agreement offers. Now, please remember, this is an example, an illustration for impact and for effect, but a real type example. I've seen offers go from $15,000 to hundreds of thousands of dollars. Rare, but occurs. So the difference between that landowner just signing what was presented to them or getting information, learning what your leverage is, deciding how you want to use it. Those things are critical. So we can see, I've seen people make literally hundreds of thousands of dollars. Now, sometimes somebody comes in and say, look, this is authorized under your lease. There's really not much we can do here. So let's get in and out with the best possible agreement. There's things we can do, but let's limit it and then get in and out. We don't need to make this like we're negotiating world peace here. Now, please don't take that to say, well, when the landman told me it was allowed under my lease. You're not represented by the landman. Even if you're not represented by me, you're certainly not represented by the landman. So do not let them just say to you, this is authorized under the lease. They can say it all they want. You need more information because maybe it's authorized on the lease, but maybe some part of it is, but the other part isn't. Many things that you have to consider. Whenever they just say to you, this is allowed under the lease, yellow flag goes up in the air, maybe red flag. You need to independently determine that. I am Attorney Doug Clark. You're listening to All Things Marcellus. We're here every Sunday from 8 to 9. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark from the Clark Law Firm. And again, we're here every Sunday from 8 to 9 a.m. and then also on the websites. You can go back to PAGasleaseattorney.com, pipelineattorney.com. We archive the radio shows. We're also on iTunes, so I always find that entertaining. It's hard for me to say it without kind of chuckling here. But we're also on iTunes, so you can go to the podcast section and type in All Things Marcellus. We're free, available there as well. And like I say, this isn't to be one giant commercial, but it is important that if anybody does need assistance, you can always contact me, 570-307-0702. If it's not me, make sure it's somebody on these issues. But I really believe with all my heart that everybody should be informed about these royalty issues. And I do free, confidential, and I can't stress enough, no obligation evaluation of your lease and royalty checks if you're receiving them to give you my opinion whether I believe that the gas company is taking deductions without the authority to do so under your lease. I want to stress that I cannot tell you whether the deductions that are being taken are excessive. In other words, if you're having $100 in deductions or $1,000 in deductions, I can't say, wow, those are too high, because we don't see what those contracts are. But what I am looking at is the category of deduction, the language in your lease. Do I feel, in my opinion, that the language in your lease precludes the company from taking deductions for post-production costs from the wellhead to the interstate pipeline? And is the company doing that in violation of your lease, in my opinion? And write back to you and say, look, here's what we believe is going on. Here's the opinion. Do a lot of negative letters. A lot of times I say, unfortunately, I believe based upon the state of the law today that what the company is doing is authorized. Now, that's my opinion. And the same whether you get a negative or a positive letter, that's my opinion. You can follow up with whomever you'd like to follow up. You can do something or not do something. We represent about 160 individual clients at the present time in our fight against Chesapeake to say, hey, stop taking deductions, but then also that the proposed settlement that's been filed in Demchak versus Chesapeake, where, if approved by the court, and it is approved in this class, the members of the class going forward would receive, instead of right now where they get no money, no share of those post-production costs, starting September 1st of 2013 moving forward, instead of deducting 100% of the post-production costs, Chesapeake would deduct 77.5%. Other companies deduct nothing. So this is very, very important fact. Statoil, under the same exact oil and gas lease, does not deduct anything. So my clients who get checks monthly from Chesapeake and Statoil under their one single lease, their same lease, Statoil, if you have the market enhancement clause or similar language, does not take a dime, a penny for deductions from the wellhead to the point of sale. As it stands now, Chesapeake is taking 100%. If the settlement is approved, which we are objecting to, but if it's approved and it goes through, if you're a member of the class and you do not opt out of the proposed or the ultimate settlement, if it's approved, you're, for the lifetime of the lease, so many decades most likely, if you're in an area of production, for the lifetime of the lease, Chesapeake will take 77.5% of those deductions. So what we're seeing, and something that's so important, in most cases we are so far in the infancy, just at the beginning of this. So you're talking about one well. This doesn't just apply to one well. This applies to each and every well that is involved in production from your property. So if they're planning 6, 8, 10, and you have well 1, this is just the beginning of this. It is for the lifetime of your oil and gas lease. What you do with the information is entirely up to you. But you must, in my opinion, get this information and make an informed decision. You don't just have to take my opinion, my word. Demchak versus Chesapeake is filed in the Middle District of Pennsylvania. Federal court. You can go check out those filings. Go to pagasleaseattorney.com, our website. A lot of information up there. Great starting point. Documents are filed. You can look at it. You can get some thoughts and impressions there. Be informed. I've done many, many shows on this topic. Be informed. We have 160 clients that say, hey, we're objecting. We want to be a part of this objection. We don't believe this is right. Be informed and make the right decision for you. I am Attorney Doug Clark. This is All Things Marcellus. We are here with you every Sunday from 8 to 9 a.m. And then all the radio shows are up at pagasleaseattorney.com and available for you there as well. Okay, I want to turn the page a little bit and go back, turn the page backwards a little bit and just finish up on these amendments and modifications. I just want to finish up my final point. If you get amendment and modification, you must understand it. You must make sure that you know exactly what's being asked, and then you must make sure you understand whether you have any leverage to try to make this thing a better situation for you. You must understand if you don't have any leverage and what could happen if you just refuse to sign this. You need to always understand the positives and negatives with any agreement that's placed in front of you. And in my opinion, the first thing you should always do is go ahead and reach out and get assistance by somebody who can guide you. Whether me or somebody else, get assistance by somebody with some knowledge and experience, and don't be afraid to ask them, have you done this before? I welcome that question. Hey, have you done this before? What are your experiences here? Ask those questions. Make sure you're getting quality assistance. These matters are just simply too important. So to finish up, you get this amendment modification. I talked about sometimes you have a request to consent to assign to a different company. And that consent has a provision that says in your original lease that if the company who holds your lease wants to assign or transfer your lease to another company, they have to ask you for permission or consent to have this assignment occur. But it also says typically that you cannot unreasonably withhold consent. You can't just simply be unreasonable and say, no, I'm not going to do this. I'm not going to agree. You have to give a reason, and it has to be a reasonable reason. Can't just say, no, I don't like that company's logo. That's not a good reason. But here is a good reason to think about. Maybe your lease is currently held by a company that does not take deductions for post-production costs if you have the market enhancement clause or similar language. You must first know whether your company does that, because you might be in a situation where you're not even receiving royalties yet. So if you're leased to a company like Talisman, Southwestern, Cabot, for example, WPX, and these companies approach you and say, hey, we would like to assign all or even a portion of your lease to another company. And remember, it's not always a complete assignment. We're seeing more and more. A company owns 100% of your lease, but they want to assign 10%, 7%, 30%, whatever that number is, but a portion of your lease to another company. My first question is, okay, who is this company? And do we know whether this second company takes deductions for post-production costs under the terms of my lease? Because if this company does take deductions, and my first company who I'm currently leased to does not take deductions, maybe I want to object to this assignment. I stress again, you have to look at this as an individual. This isn't general advice, but this is very important for everybody to be thinking about this. Here I am, leased to one company. They want to assign my lease a portion of it or all of it, but usually let's say a portion of it here in this example. They want to assign a portion of this lease to another company, and I know that other company, that second company, is taking deductions. And let's play this out to make it simple. Say I'm getting royalty checks right now from my company who wants to assign it, and there are no deductions for post-production costs because I have the market enhancement or ready for sale or use or similar language in my lease. The second company, though, is Chesapeake. And we know that Chesapeake is going to take deductions under that exact language. My first question is, why am I going to agree to this? Is there a reason that the company can provide me where I'm going to knowingly expose myself and my lease to be transferred to a company that's going to pay me less in royalties with respect to deductions? Now, maybe the gas price may be higher in a month or things like that, but it's going to be reduced, at least in that there's going to be deductions taken. These deductions can be substantial, hundreds, thousands, tens of thousands, and over time, depending upon the acreage, hundreds of thousands, and even into the millions of dollars. So this is critical. You need to understand that. This is a tough issue to just sit there on your own because there's so much involved. And it's an individual circumstance. It's not just something where I can sit there and say, don't do it, don't do it, don't do it. We have to look at your situation, your acreage, the development, what's going on. There's so many things that you need to investigate. But it is worth the time and investigation because these are high-value matters. Could be the difference of hundreds of thousands of dollars in cases, and even more, in some cases less. But these are very important issues that people need to be thinking about. And I assure you, circling back to my landman not working for you, they're not going to come out and knock on your door and say, oh yeah, by the way, when you sign this and we assign it to this other company, they're going to start taking deductions, and your first company isn't, but the second company is. They're not going to tell you that. So you need to find that out on your own. You need to find that out on your own. And then step 2, what can you do about it? What leverage do you have? Is it a situation where, yes, you understand that they can and they will be taking deductions and your first company isn't, but you're in a trap? What do? It's the better of two evils. That may occur, it may not occur. You may be able to say, you know what? No, I'm not going to consent to this assignment. Stay with your company and possibly for the lifetime of your lease, never have deductions taken. But I want to leave this segment again saying that please understand. Please, this is general information to get you thinking, to tune you into the issues. This is not individual advice because some people are going to want to not consent to this type of situation. Other people may have no choice. In the end, it's the better of two evils. This is a situation where you have to get good quality information. It's complex, it's not easy, but it's super important. I am Attorney Doug Clark. You're listening to All Things Marcellus. We're here every Sunday from 8 to 9 a.m., and we'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, we're here with you every Sunday from 8 to 9 a.m., and you can go back to pagasleaseattorney.com and check out prior radio shows. I've been doing the show since August of 2010, so 140 plus hours available on the websites, and also go check out a lot of great pipeline information. I was going to get to some pipeline stuff today, but I can tell, as often is the case, I'm not able to get to everything I want. So we'll be doing more pipeline shows upcoming. And I did a show discussing a lot about pipelines last week. So you can go check that out again at pagasleaseattorney.com. But visit the pipeline site as well, pipelineattorney.com. Don't let the attorney part fool you. A lot of great information there. Get some information. Understand, when you go into these negotiations, you want to be informed. You want to get assistance. These are powerful legal contracts. I'll say that often. You need to get that help, and you need to understand the leverage. So if you're looking at a pipeline agreement, you're faced with that, first thing you do, or if you think you might be, you hear your neighbors getting the rumblings, go check out pipelineattorney.com, get information there. Of course, we switched stations recently. We have a much bigger audience as far as the areas where we have our landowner clients, where I have my clients. Bradford, Susquehanna, Lycoming, Wyoming. I have clients all across the state as well. But we switched over, so I know a lot of people are hearing the show for some of the first time. So there's really a plethora of information out there available through the websites. And never be afraid. You can always contact us directly at 570-307-0702. What I tell people, certainly every one of my clients and any Pennsylvania landowner, frankly, if you're asked to sign a document, you shouldn't be afraid to reach out to speak with an attorney. So if you're asked to sign a document, you can contact my office, 570-307-0702. Look at it. We've seen them all, or almost all of them before. Any and all agreements, contracts, documents related to natural gas development here in Pennsylvania. So we'll look at that and say, okay, hey, yeah, this is something you might need assistance with. And if you're interested in that, we'll give you some more information. Or, again, we wouldn't have a legal relationship or contractual relationship over the phone, but can give you just at least a little bit of an idea as to the magnitude of that type of an agreement. Some agreements you absolutely need some substantial assistance with if you're going to proceed. Some agreements just, or documents aren't as serious, but the critical part is the understanding what type of document or what you have in front of you. So never be afraid to reach out. You're always no obligation. You can contact us anytime. Contact me at 570-307-0702. Another thing with the websites, I want to encourage people as we do kind of transform and we get some new audience members here. If you have show topics, and what I normally do is I have the week during the week, and I'll make notes or I'll do little memos of myself. Hey, radio show topic idea. Well, back in August of 2010, I thought, oh my heavens, how am I going to fill up the first show? And now I have this laundry list of topics to address. And of course, the royalty issue and the deduction issue has taken so much time, and it's such an important issue that it's really given me a lot to talk about and a lot that we need to address. But if you have topics, if there's things which maybe you're presented about and say, hey, will you talk to me, or presented with, and you say, hey, will you talk on the show? I'm interested in hearing about this topic or some impressions. Never be afraid. Go to the websites. You can do it anonymously if you like at pagasleaseattorney.com or pipelineattorney.com. Shoot an email over. Say, hey, would you consider talking about this or offering some general information on this topic? My goal is to use the show as a way to get landowners information. Certainly, there's commercial aspect, and I'm a believer in just being honest and upfront. I try not to just sit there and pound you with my telephone number. Call me. I do believe that people need this assistance. I really believe it, and you need legal assistance, and you need to be comfortable with your attorney. You absolutely need to be comfortable with that person. If I'm not the person for you, and that's certainly possible, we want to make sure that you're thinking about certain things, that you're understanding concepts, that if you have a different attorney, you're asking that attorney questions. I want everybody, I really truly want everyone in Pennsylvania, all landowners and all royalty owners, to get the best possible deal or agreement that they can, not just compensation, but protecting your property as well. Growing up in rural Pennsylvania in the western part of the state, I just see this in every case. I see my grandparents, I see my neighbors, I see the people that I grew up around, and seeing this development happening to them, and having the opportunity to try to assist them and try to assist people. So I think it's our obligation to communicate, get information out there, whether we ever talk personally or not. Really want to make sure that you're thinking about things, you're in tune to these things, and you're up to speed, and you're making the best decisions. I know, growing up, my parents, I don't ever remember them going to see a lawyer ever. My entire life, the whole time I was at home, never remember that. I can remember my grandparents going to see a lawyer in the town right down the road from us. And I remember my grandfather all dressed up and going to see the lawyer and said, what's going on? Grandpap, what are you doing? And they were going into the lawyer to do something with their wills. And I thought, wow, the whole idea of a lawyer was that concept was just distance. I didn't know any lawyers. I never knew a lawyer. I never knew my parents to go see a lawyer. So I know that can be intimidating for people, because I know it was certainly for my family. So I just want everybody, you never should be intimidated. And we certainly try at our office to make sure that, and we do look at it. We have kind of family relationships with our clients. And you got to find what's right for you in your situation. But please, do not be afraid to reach out to an attorney, whether it's me or somebody else. Don't be afraid to do that. believing that companies have attorneys. This process has evolved for over 100 years. Gas and oil production, it's not new. These contracts have evolved that every time there's an issue that comes up where the company has a problem, where maybe there was a way that a landowner had an opportunity under a contract that protected them, well, what the company does is say, whoa, well, okay, we didn't like what happened there because of this language, so you know what we're going to do? Let's amend or change the language in the next contract that we hand out to landowners. So when you get that form gas lease, or you get that form pipeline right-of-way agreement, or that form meter site agreement, a compression agreement, compressor station agreement, when you get the form water withdrawal agreement, when you get that handed to you, that didn't just get made up. That has evolved to be a very company-friendly document. You need to understand what that is and how you can maybe make that better, how you can start adding terms to make this better for you. You need to understand that, and you need to have somebody working with you who can explain these things to you and knows what to do and what to ask for. So be thinking about these issues. There are people signing all the time who are signing bad agreements, and had they better information or more information, they wouldn't be doing what they're doing. They would be saying, okay, well, let me evaluate this more. And sometimes it's just so easy and so simple. Through telephone calls and just inquiring, you can significantly change what's presented to you. So you owe it to yourself, I really believe it, to get this information. The show, I think, is hopefully a very good resource for people. The websites, I pound it, pagasleaseattorney.com and pipelineattorney.com, I know are great resources. Get out there, get the information. Remember, though, going into these message boards where people are just typing up things, and doing it anonymously, there's some good information out there, but you're sifting through to find the good and being careful to avoid the bad. And I can tell, I said this, I don't go on these very often, but every once in a while I find myself, for some reason, being on a site that has these message boards, and I read things and I think, oh my heavens, this is just simply not the way it is. This is terrible advice. I hope nobody's following it. And at times I'm confident that it's company representatives who can anonymously write whatever they want, writing this information there. And then I wonder, you got all these people that are just writing this information, who's doing it and what's their motivation? So you need to understand, whenever you're taking advice, what is that person's motivation? And when you're looking at your neighbor or somebody that's went through the process, what is their experience? They went through the process once with one company, with multiple companies. It always drives me crazy and it happens, that's just the way people are at times, but people like to give other people advice based upon whatever their experience is. And when they do that, that's the personality. Whenever you're saying, okay, well, you should do this or you should do that. When people are telling you what to do, not giving you ideas or things to think about, but, oh, you should do this, you need to do that. Please be careful. Please be careful, because how do they know that? And they start telling you should do this or you should do that. I laugh. I was doing a remodeling project at the house and had a certain idea of what we wanted to do. And a friend of ours was over and we were talking about what we were doing. And he was like, well, you need to do this or you need to do that. And I just laughing to myself. He's a friend of mine and nothing negative, but thinking, I've actually thought a lot about what I needed to do or what I want to do. And my wife and I are going to do it the way we want to do it. But I appreciate your advice. So it's not, and it's the way it was presented. And what I laugh at is not like, hey, did you ever think about this? Did you ever think about doing this? No, it's, hey, you need to do this. You should do this. And essentially, if you don't do this, you're making a bad decision. Well, if somebody is saying to you as a landowner, neighbor, friend, relative, you need to do this, you need to do that, remember, what is their experience? What do they really know about this? How many times have they done this same thing before? When did they do it? Because 2014 is a world of difference between 2012, 10, 11, 9, and even 2013, depending upon what we're dealing with. So please, you can't just say, well, my neighbor did this guy did this, the other guy down there has a lot of acreage, he did this. Every single circumstance is different. They're all different. Every person is different. Acreage is different. Companies are different. Leverage is different. Where the wellbore is different. There are so many factors that you need to be looking at. So we're hoping that people are thinking. If you need any assistance anytime, give me a call. But get help, get informed. You're listening to All Things Marcellus with me, Attorney Doug Clark. We're here every Sunday from 8 to 9. Have a great week, everyone.